Once Congress gives that power up, it's very hard to get it back because they have to pass it through two houses and get it past the veto power of the president.
Congress has just allowed its power to slip through its fingers bit by bit by bit.
I think all three of us agree that as a practical matter, that this is probably not best for the country. There was a big legal argument today in the Supreme Court where the question is, as a legal matter, slightly different from the question of what impact will it have. The question as a legal matter is effectively, can Congress put tenure on particular government agencies where they say, for example, this person is appointed till 2029, right? And those people end up being protected, meaning the president can't fire them. The president has come in and fired a Democratic FTC member named Rebecca Slaughter before her term was set to expire. And the lower courts have sided with her, in part because there is a Supreme Court case from 1935 called Humphrey's Executor versus United States, which limited the presidential power and protected the heads of these independent agencies. It was very similar to the issue here today. And basically, the government is asking for that to be overturned, saying, it doesn't apply really anymore. And for those reading the tea leaves, the Chief Justice told the lawyer for Slaughter, with regard to that opinion, Humphrey's Executor is just a dried husk of whatever people used to think it was. So it was addressing an agency that had very little, if any, executive power, and that may be why they were able to attract such a broad support on the court at the time. That does not sound like someone who is ready to uphold that previous decision. Now, if the court overturns it, it would have very significant impact on between 20 and 30 agencies, all right? And they include the Commission on Civil Rights. It includes the Federal Labor Relations Authority, the Federal Trade Commission, which is relevant for this case, the Legal Services Corporation, the National Labor Relations Board, the National Mediation Board, the National Transportation Safety Board, the Occupational Safety and Health and Review Commission, the U.S. Institute of Peace. It might have an impact on the Federal Election Commission and even the SEC. That's a little less clear. But it would have enormous impact and basically allow a president to come in and fire everybody. And this is really what's a balance of power fight, right? Does Congress have the power to protect these individuals for a certain amount of time, or can the president come in and fire everyone? Now, the policy questions are slightly different, right? Is it a good idea? Isn't a good idea? That's not really the legal question at issue, although some of the liberals on the court were focused in the arguments today on what the impact of this would be. And Justice Sotomayor, in questioning Solicitor General Sauer today, seemed to focus on that. Let's play the longer version of this. This is number 8. This is the back and forth today.
You're asking us to overturn a case that has been around for over nearly 100 years, correct?
90 years, I believe.
90 years. What other cases have we overturned that have had a pedigree of 100 years?
POTUS against Neff was overruled by Schaefer against Heitner on its 100th birthday.
That was an economic case. What other case?
For example, Erie overruled a Swifty Tyson 96 years later.
But which other case has fundamentally altered the structure of government? For over 100 years, actually since 1887, we've had multi-member boards, and that's the entire government structure.
The distortion of the structure of government, respectfully, that Humphrey, the philosophy of
aren't you asking us to distort it a different way?
I think we're
neither the king, nor Parliament, nor prime ministers, England at the time of the founding, ever had a unqualified removal power. You're asking us to say that at a time, the founding, when the Constitution doesn't speak about this at all, where there was robust debate over this issue among legal scholars at the time, that we ourselves has said repeatedly in Humphreys and other cases, Wiener, even in Myers, that those cases you mentioned did not establish this absolute power of the president. You're asking us to destroy the structure of government and to take away from Congress its ability to protect its idea that
5 seconds.
The government is better structured with some agencies that are independent.
So you can see right there, that sort of summarizes the position of what it seems the three liberals were. Now, most of the time in the Supreme Court cases in the past, people say, oh, you can't tell from oral argument. I'm going to talk to two experts about this in a second. But let me play one more piece of sound. This is of Justice Clarence Thomas on the other side of this. And I believe this is him also questioning Solicitor General Sauer, but at least it'll give you a sense of where Thomas was coming from.
Give us one example of a permissible restriction on the authority to remove a principal officer.
We don't believe there are permissible restrictions on
5 seconds.
States who exercise the executive power. Now, there may be separate issues relating to particular historical pedigrees.
You get the idea. Let me bring in my guest, Don Kettle, Professor Emeritus, former Dean of the University of Maryland School of Public Policy, and Stanley Brand, Distinguished Fellow in Law and Government at Penn State Dickinson Law and a Washington, D.C. attorney. Gentlemen, thanks very much for joining us. Appreciate it. All right, Stanley Brand, let me start with you. You listened to the entire arguments today. How telling do you think they were? You know, all the media reports right now are conservatives set to overturn this opinion. What's your take?
Yeah, not so much based on the oral argument, but based on the progression of cases that the court has decided previous, including the Consumer Protection Financial Board, SEAL, and other cases, which I believe has signaled that Humphrey is on life support and has been on life support at least for the last decade under this court. So I think it is fairly predictable that, at least as to the FTC, leaving aside the Federal Reserve and some of these other sui generis agencies, you can expect 5 justices to side with the solicitor in this case.
And I think you bring up a good point, which is the justices in this argument also specifically seem to distinguish this from the Federal Reserve.
Yeah, and they had done that in an earlier case, Dan, in a sort of gratuitous way, when they said that don't construe this as affecting the Fed because the Fed is different. It's privately funded. It's got different functions, and it's been around in some form or another since the Second Bank of the United States in the 1800s. So there's that historical liquidation theory floating around in this case, that historical practice can help the court interpret textual provisions that aren't clear in a particular case.
Don Kettle, you think that slaughter in this case has any hope, or is this kind of a done deal?
Well, I think we're heading and have been heading for a long time in this direction. I think the court seems likely to overrule Humphrey's Executor, which sounds like such a dry case, but it's a precedent that's been around for 90 years. And the argument is that the president ought to have the power to fire anybody who works for the executive branch, especially people who are head of the Independent Regulatory Commission. So the argument here is that these independent regulatory commissions should not be independent, and that the commissioners should not be independent of the president. So I think that the conservatives in the court have been angling for this. And one of the things that I think is important to point out, too, is that from the first day this administration walked in the door, they've been driving toward this day. And I think that they picked this case as a way to try to put their argument across. And so this is a precedent that they badly want to try to upset.
Stanley Brand, I mean, isn't that true that as a practical matter, and now we're going a little bit away from the strictly legal analysis and talking about the practical implications, isn't it true that if this Humphrey's Executor case gets overturned and the president is allowed to fire this FTC member whose term wasn't set to expire until 2029, that these regulatory commissions really no longer become independent.
Yeah, I think that's right. And look, this has been going on for 100 years. This is the fight over the administrative state and the congressional power to delegate. I argued the legislative veto cases in the Supreme Court for the House in 1983. And the court threw those out, said they weren't properly, gone through bicameralism and presentment to the president. And the argument on the other side, which was actually adopted by Justice White at the time, was, well, look, we've been doing this since, at least the Roosevelt administration. And the Congress and the president have come to a compromise and allowed this to go on. And that's what the argument was here. The question was, regardless of how convenient it is, or whether the branches agreed to it, does it violate the structure of the Constitution? And in the legislative veto case, the court said it does and threw them out. That's the same argument that's going on here. And yes, you're right. It could affect the SEC with one caveat. The president could fire everybody who works at the SEC. He's still going to appoint people who are in charge of interpreting the statute. He's not doing away with the agencies. The agencies still exist. They exist under a different, political leadership, but they'll still be charged under the statute with enforcing the law. Now, how they do that is obviously a question of discretion.
Well, Don Kettle, should that provide any sort of reassurance?
No. And the reason is that the idea of enforcing the law means that people have to interpret what the law means. Congress, under the Constitution, has lots of powers, including the power to make laws. But one of the things we know about the way it writes laws is that often they're very vague necessarily, and that the reason why we have these commissions is to make interpretations based on both what they think Congress meant and also what it is that the facts provide. And so once you start allowing not only this more discretion on the part of the independent regulatory agencies to administer the law as they see fit, but also the president to put the squeeze on these agencies through the appointments at the top, it really means that the nature of the decisions coming out of these agencies is likely to shift. It's likely to change. We're likely to see changes from administration to administration.
Let me ask you about that. Let me just follow up, because obviously you seem concerned about the impact of this. What is, as a practical matter, now we're fully into the policy realm, right? What do you see as the practical impact that will happen as a result of this change?
Look at the FTC. Look at the questions of some of these mergers going on about who is going to control which part of both TV studios, movie studios, and online streaming. And if you've got a previous administration who said, I'm not so sure that I think that's a good idea, a new administration more in favor, for whatever reason, could come in, take away the commissioners in charge of making that decision, put in place people who would change their mind, and then change the policy of the agency. So we could see policy in these independent regulatory agencies whipsawing back and forth from administration to administration. And Congress set these up as independent in part to ensure that they had expertise, but also ensure that there was some predictability in policy over time. And by making it possible to change people at the top, the predictability goes out the window.
So let me just say to that, Dan, because this is important. That's already happening without Humphrey's executor being thrown out the window. Trump appointed pro-business people to the SEC. They've done away with crypto. They've done away with the Foreign Corrupt Practices Act. They've done away with all kinds of enforcement. That's what happens when you switch administrations and you allow the president to have a majority on these boards, which is what the statutes provide. Now, I don't want to sound like the conservative here, because I'm not. All I'm saying is that is the way the system works, even without Humphrey's executor.
Yeah, but let me take it up a notch if I could, because if you look at the agency that's in charge of hearing appeals by federal employees who think they've been treated unfairly, what the administration has done by taking out the Democratic appointees that were put there in place, and in some cases not even appointing replacements and choosing to let the positions remain vacant, is it's essentially cut the ability of those agencies to hear any appeals by feds who think they've been treated unfairly, just throwing that out the window. And so one of the problems is it's not only shifting policy and making the question of policy something that could whipsaw back and forth, but also simply immobilize the agencies to begin with. And
Yeah,
in some cases, that's what the administration has in mind, I think.
That's a good point, because that happened in Noel Canning, which was the National Labor Relations Board case, where President Obama tried to make a recess appointment to the NLRB because it didn't have a quorum. Yeah. And a different Supreme Court unanimously, with all the liberals voting with them, said, no, if you try to put someone in a time period of less than 10 days, that's not a recess under the recess clause provision of the Constitution. So that those types of separation of powers issues have been, litigated before. I don't think I heard anything in the oral argument about the point that Don is legitimately making, although, Justice Kagan basically, to me, made the most compelling question, which was, where does your theory stop? What line are you going to draw?
Let me play a little bit from Justice Kagan today. This is number 14. I'm not sure if this is the specific point you're referring to, but let's listen. Number 14.
Let me put the proposition in a sort of different way. Here's been the bargain over the last century, and I think it has been a bargain. Congress has given these agencies a lot of work to do that is not traditionally executive work, that is more along the lines of make rules when we issue broad delegations and do lots of adjudications that set the rules for industries and entire bodies of governance, right? And they've given all of that power to these agencies largely with it in mind that the agencies are not under the control of a single person, of the president, but that indeed Congress has a great deal of influence over them too. And if you take away a half of this bargain, you end up with just massive, uncontrolled, unchecked power in the hands of the president. And it's really hard to affect both sides of this bargain because it's already been done. So the result of what you want is that the president is going to have massive, unchecked, uncontrolled power, not only to do traditional execution, but to make law through legislative and adjudicative frameworks.
Stanley Brand, I don't know if that was the section you were referring to.
That's close enough. Yeah. And look, this goes back to the question of delegation. And I've served as counsel to the House. I encountered this all the time. Congress couldn't come to a political consensus on what the standard should be for the EPA or name whatever agency you want. So what do? They write a general statute with very unclear specific standards. And they say, well, we'll let the bureaucrats fill it in and the courts decide it. And that's been the objection of the conservatives since the New Deal, is that this is a gross expansion of power given to bureaucrats instead of Congress, the elected branch representing the people, making those decisions.
And wait a sec. But Stan, I want to make sure I understand this, though, because if the administration wins in this case, does it eliminate Congress having any power when it comes to these independent agencies? I mean, will Congress still have any role at all?
Well, they have advise and consent to confirm, and they also have statutory authority. They can always revisit the statute which they've delegated the power to and redefine that power. The problem with that is, as Justice Gorsuch pointed out in a recent case, once Congress gives that power up, it's very hard to get it back because they have to pass it through two houses and get it past the veto power of the president. And so, in the tariff case, that was the main problem that Gorsuch had. So, yes, it makes it very difficult for Congress. Doesn't make it impossible, but it makes it a much harder road to hoe for them to reclaim that power.
Don Kettle, go ahead.
There's that for sure, because Congress has just allowed its power to slip through its fingers bit by bit by bit. The reason why we're sitting here right now, in fact, is that the Congress simply has not been able to legislate clearly enough what it is that it has in mind. And for all the reasons that Stanley is pointing out, Congress just finds it very difficult to do its work in a timely way and clearly enough so that it can avoid leaving lots of discretion out to the federal agencies. And so what we have is a question where where Congress just allows its ability to be able to shape policy, to slip through its fingers to the executive branch, and the increasing the president's ability to control what it is that these agencies do by putting new appointees in at will without respect to whenever it is that their terms may be up only increases the slide downhill from Congress to the president. And that question about where we stop is something that is very much out in the open now. And make no mistake about it, this is not the end of the road for what the administration wants to do. It wants to make all federal employees at will, not just the commissioners of federal regulatory agencies, but all federal employees. And you can see that in a lot of the executive orders that it's issued. That's where it wants to go.
Let me ask you each a final question. I think all three of us agree that as a practical matter, that this is probably not best for the country, that it's probably a good thing to have some level of independency of these agencies. But I want to focus specifically on the legal question for a moment that the court is being asked to answer. And Stanley Brand, I'm going to start with you, which is when it comes to the balance of power, not asking whether it's a good idea, but based on constitutional assessment and interpretation, do you think there is a legitimate, if not compelling, argument that the administration has made here that this is not something where Congress should have the power to put these kind of tenure periods on these agencies?
Yes, at least with respect to what they have said are purely executive agencies. And so, this is where.
So you think they have a strong legal argument?
I do, because you go back to Myers versus U.S. and they said you can't inhibit the president's ability to terminate people appointed under the Appointments Clause. That's part and parcel of accountability for who he picks. So, and I agree with Don. This is a major shift if this goes in. And it's not going to stop here, despite what Sauer tried to weasel out of an argument by saying, well, we're not arguing that here. They're going to argue that in the next case if they win this one.
Right. All right. So Don Kettle, Stanley Brandis has said that he thinks that they, on a strictly legal basis, that they do have the administration does have a compelling argument. What say you?
My view, for what it's worth, is that, and it goes way back to the Constitution itself, there's that the Constitution, first of all, is relatively quiet on this. And so we have to try to figure out what it is that Congress, with its original intent for the Constitution, really had in mind. And it did not limit the ability of Congress itself to be able to make these decisions. If you look across the federal government, we see Federal Reserve Board members have long terms set by Congress. The head of the Government Accountability Office, a legislative branch, but still a branch that has substantial power with a presidential role and appointment, has a very long appointment. There are varying appointments for different officials throughout the federal government. And I find it hard to accept the idea that the president can tell the Congress just how far it can go in legislating. And in terms of the basic constitutional issues, it seems to me that for the president to assert that Congress has limits on what it can legislate about and have the Supreme Court agree is, I think, a massive shift in the balance of powers.